to our Creator, to all beings of love and light to assist us here to not only overcome, but overwhelm the forces of energy that seem determined to repress us, our lives, our very spirits. As children of your divine creation, we recognize we need assistance. We need more to awaken to the truth of the injustices, and we need them to take action with us to alter or destroy the systems that are establishing as school policy, as public policy, as equity policy, and all notions of minds willing to bend our free will into conformity to theirs. We will not. Our will is thy will. And so long as we are honoring our free will spirit, a spirit born with unalienable rights, to express our creative, compassionate, intelligent selves, then we choose to exert our free divine selves in defiance of any authority any choose to impose. Let this be so, and so it is.
Hello, my name's Ron Vroman. I'm the old white man talking head for the Oregon Statewide Jural Assembly. This is an update, I guess it's a good one, on our quest to find sheriffs on Oregon with the proper bona fides, with a bond and an oath, and prepared to do their work. Well, we tried 36 of them, and all 36 of them failed to provide the documentation needed to stay in their office. So then we went to 9 of the 36 and posted on their bulletin boards, such as they were, and spoke the word to them and delivered them papers of what was required of a sheriff on Oregon, and that they were all failing. So to have the authority to do this, you've got to understand there's a de facto and a de jure. And it's just clear that on Oregon, the de facto started November 8th, 1910, and all 36 of our sheriffs so far have agreed to the fraud, the deception of Article 7 amended in Oregon's Constitution. When you're a sworn Leo or such, military even, and you have an oath to defend and honor the Constitution of the United States of America, and possibly Oregon also, and the statutes and laws, when you take that oath, then you should understand what you're doing. I spoke with a lady the other day, a recorder for a county, and she confessed that she didn't know much about the Constitution that she took an oath to and that she records for. That's sad. On Oregon, years ago, they passed a law that said that the Constitution and history of government will be taught for 5 years on Oregon, starting no later than the 8th grade. And that was made a law and passed, and it's on the books, and they do not do it. And nobody holds them accountable. Well, the same thing is happening right now today with our sheriffs. I just got off the telephone with Melissa Duncan. She's the sheriff on Lynn County. We have 4 female sheriffs in our close vicinity: Washington, Multnomah, Clackamas, and Lynn. All 4 of those counties are headed by a female sheriff. Not one of them has their bona fides in order. Not one of them has their bond and oath in order. And I find it difficult to believe in the job code of sheriff. It's not like a job code that's visited by a lot of females to begin with. It's out on the bell curve. But they have all female sheriffs. And statistically, that's not possible. It just can't happen unless it's made to happen. So, therefore, it is not properly selected. It's passed on as it is deemed to be. It's not an election, it's a selection. So, in the past, when we had a benevolent form of martial law, the sheriffs and others would pretend to provide their bona fides, and it never got bad enough so that one of them actually got recalled. It would get bad, but they never recalled Kate Brown either. They tried forever to get her, and they could never get it done. The legal system is designed for that to not happen. If it does happen, it's got to be absolutely rare. So we're doing the investigation on 9 of the 36 sheriffs, 25%. Josephine County, Jackson County, Lane County, Lynn County, Marion County, Clackamas, Multnomah, Washington, and Yamhill. The Yamhill Sheriff Elliott has blocked me. With the security system, he blocks my email. That's a due process violation, and it will be prosecuted. Next, the Oregon Revised Statutes 206 says how we go about having a sheriff, how we go about having an elected executive for our county that is expected to operate for our peace, safety, and happiness. How do we go about doing that? Well, we go about doing it lawfully and legitimately. And part of it is a candidate must file the paperwork. And the candidate files the paperwork with the county recorder saying, I'm qualified to run for this office. And they receive it. Then they check it out. And the Department of Administrative Services, nope, that's the wrong document. And that's the wrong document. Here's the correct document. So in Michelle Duncan's case, you can't make these names up. A fellow named Steve Drunkenmiller was the county clerk, and he accepted her papers September 2021. And he solicited the Oregon Department of Public Safety and Standards and Training. And they provided him with a letter really quick. I mean, it looks like it was prepared before this was filed. In any case, DPSST said, Stephen, the eligibility for Michelle Duncan Kelly is okay. She can run for sheriff. So then we have a document here that says that Michelle signed it in September and that she has these qualifications for sheriff candidate eligibility. And that's all they have in the way of documents recorded for Michelle in Lynn County. That's not acceptable. That's not meeting the requirements of the job. That's illegal and deceitful because she's in the position. We served the papers on her of what a proper oath looks like. Not exactly, because We can't dictate your exact oath, but we can come close. And it will contain certain information. And it'll be written and it'll be spoken. And we will hear it. The people will hear it. And they will hear it in open court. Probate. Caveat to will. We, the people, will know. So, this is the position we're in. We do not have the paperwork from the Department of DPSST, and we've tried many times. Our Marshal Bobby and our clerk Brandon visited DPSST twice, making our needs known, and were refused both times. I've sent multiple emails. They do not cooperate. I recently saw that several of them have been put on leave. They do not return phone calls, nor do they return emails. But as we do not have the documentation from them, however inferior they may be, we have zero information from Michelle. So we contacted Michelle many times, and Michelle refuses to communicate. The first time we contacted her in writing and in the word about her oath and the verdict of our court, she sent her undersheriff, and he heard it, and he received it, and he was rude. And our court left. And we filed our paper with the county on the public bulletin board, pardon me, which is a glass locked box in Marion County on the porch of the courthouse. The only proper one out of 9 counties. You would think they could do better. The newest courthouse in Portland has failed twice, and we reposted our documents on it yesterday for the 3rd time. However, I digress. We're dealing with Lynn County. For some reason, it came to the foremost, which is fine. We got 9 to push through. So I have all that's available to me from all of the sources available to offer them. And we went and saw 4 executives of Lynn County. I have their cards. Darren Lane, Laura Cease, Marcy Ritchie, and come on, Eugene Carandy. And we spoke with all of them, explained everything to them, and we were politely and well received, although we did not get the HR requirements for sheriff. They withheld them. They're forthcoming, I'm sure. And then I sent them all an email from Proton, which provides an excellent service for email. And then the next day I sent them another email, and the second email was blocked by a company called Barracuda. That is not due process. So what we're dealing with is Lynn County. It's not just the office of sheriff that's not providing due process, but it's 4 departments within the county that is not providing due process. Due process is all written down. It will be done this way, or you are not in compliance. Therefore, you are out of compliance. Therefore, the sheriff has no honor and cannot hold a position of trust, nor can anybody else in Lynn County that violates their trust. It's incontrovertible evidence. It's not open for discussion or belief. So in the paperwork we received from Marcy is the original document Michelle provided the county, and it had a phone number and it had an email on it. I responded to the email asking for an appointment, and then today I dialed the number on the document, and the phone was answered by a female. I said I was calling Michelle, and she said, "I'm Michelle." I told her who I was and that we were seeking an appointment with her. And she said, "I will not make an appointment with you," and hung up. That's pretty clear. And that is a violation of due process. Due process is partially written down in ORS 206. It's also written down in two constitutions. And it's also written down in the HR requirements for Lynn County. And Michelle has been unable to prove any of the things that she states are true for her to occupy the office of sheriff. Doesn't make it. So her 60 days is up around the 16th or 17th of January. She will have been provided the 60 days again for her to get her act together so that she can become compliant. It's not difficult, but for some reason our sheriffs refuse to take a proper oath to the proper constitutions. They don't want to do that. I'm not sure why. Doesn't seem reasonable to me that you go to all the trouble to become elected the sheriff and you know you have to take a proper oath and then not take it or refuse to take a proper one and take one that's illegal and illegitimate. We're no longer received. Pardon me. We are no longer deceived. So correcting that which needs to be corrected. That seems to be what the deal is. The Judiciary Act of 1789, Section 32 says if you're knowledgeable enough in law to see an error, well, then correct it and move on. And we are knowledgeable enough in law to see the error. Due process is written down on each county. You will provide the clerk with the proper election document. You will be certified as capable. DPSST will respond. You'll be put on the ballot and elected. And before you take the office, you will fulfill the requirements of the office. And we have 36 sheriffs that failed. That's not statistically possible. You can't have 36 out of 36 failures unless they all are failing on purpose. Somebody had accidentally make it if it was chance. And it's not chance, and it's not belief. We're dealing with facts. And I yield. Hello, my name's Ron Vroman. I'm the old white man talking head for the Oregon Statewide Jural Assembly. I want to talk about rational thinking is required. There is no one to explain or interpret Article 1, Section 1, and I'll read that in a minute. This information you must be capable of accepting, comprehending, and inculcating into your being. Notice, that a special social compact is named Oregon Statewide Jural Assembly, aka Provisional de Jure Government on Oregon, as of November 2022. www.orsja.org. That is a fact. Facts are created by living testimony in the form of an affidavit of truth filed, and that is acquiesced to by the U.S. DOJ, the U.S. Marshal Service, the FBI, the U.S. Marine Corps, the state of Oregon, aka all cap state of Oregon, and defaulted on for, with, by the de facto United States of Washington District of Columbia Incorporated for profit governance since 1861. Oregon was subjugated into the fraud and the deception into the illegal and illegitimate federal, wherein the city of Portland is a subdivision of the county of Multnomah, is a subdivision of the state of Oregon, is a subdivision of the United States of Washington District of Columbia, Inc. We have the DOJ stating this in supplied records to us from the attorney for the GSA on an inquiry regarding the Marco Hatfield Federal Building. That is not a definition of constitutional Republican form of government. That building has a clouded title. All of us filed quiet title foreclosure, eviction, and repossession on the GSA, the U.S. Marshal Service, the Department of Homeland Security, and the U.S. Department of Justice. In the Marco Hatfield Building, it is a federal, bogus title indeed. That is the de facto, operated by an industrial, military, executive, legislative, judicial, administrative, banker, Federal Reserve Note, British Accreditation Registry, Nazi, Jesuit, Khazarian, jihadist, communist, UN, big pharma, medical de facto, color of law, RICO society that should not be. So we took them out on Oregon, November 2022. The federal military, Lieber Code, color of law, every court and judge of any sort on Oregon were all removed as they could provide no bona fides. This was completed on Oregon, November 2022. Martial law, Lieber Code, FEMA were de facto and were removed by implementing Ex parte Milligan, which we did in 2018. We did this by creating a jury pool that was the base to support a grand jury and a petite jury, an Article 3, one Supreme Court with a small o, a small s, and a capital C, claiming original jurisdiction found in Amendment 7, Civilian Common Law Court of Record, and Article 7 prior to 1910, which is original jurisdiction in fact. Original jurisdiction is defined in the United States of America's apostrophe S Constitution circa 1859 and Oregon's apostrophe S Constitution circa 1859, before the fraud. All of us that know will not speak truth to the de facto. Our assembly has called for and filled 9 grand juries over the last 6 years. Each one was recorded and published. Each one found presentments and true bills. The true bills went to our Article 3, Amendment 7, Civilian Common Law Court of Record. That court has 9 times. That court has met 9 times, such as the Department of Corrections parking lot and in front of the Marion County Courthouse. We set up tables and chairs and tents. It was fun. Some of our verdicts, Kate, Ron, Jeff, and Suzanne are oath breakers and have no honor and may not hold a position of trust. they will vacate their offices, as they may not hold. No, as they may not collect a fee, as they have no honor. 89 of 90 Oregon legislators broke their oath and held session with all of us excluded. They did it. They have no honor, incontrovertible evidence to due process violation. 3 men employed by the Department of Corrections denied a writ of habeas corpus ad subjudiendum. That is a violation of their obligation to the Constitution circa 1859. They broke their oath, and an ancient honor was violated. All of us on Oregon have 36 offices of sheriff, one for each county, and not one is occupied by a man or a woman with a proper oath to the correct constitutions, with the laws of nature and nature's God included, with their bona fides in order. Some have been in the de facto so long they may not be capable of filling the de jure original jurisdiction on Oregon. Actually, do the complete job with lawful deputies and in all instances. So there it is in one page. All the best of every good fortune for the good. Ron, the old white man talking head for the Oregon Statewide Jural Assembly. Now I'll read Article 1, Section 1. We declare that all men, when they form a social compact, and we did that, are equal in right, that all power is inherent in the people, and all free governments are founded on their authority and instituted for their peace, safety, and happiness, and they have at all times a right to alter, reform, or abolish the government in such manner as they may think proper. And I yield.
They do not want to let go of this. They do not intend on losing here. And we do not intend giving it back to them.
And then the bullets started flying. Then he jumps out of the car, and he's got both his hands up. And he got out of the car, and he had his hands in the air. He's like, just shoot me then. This is what you want, just shoot me. And they did. They shot him dead. With his hands in the air, and I saw it. I swear to God. He was just walking with his hands in the air. And they shot him. And they shot him dead, and then after he was down on the ground, they shot him 3 more times.